Good afternoon and welcome. My name is Erin O'Brien and I am a legal assistant with the Unemployment Law Project. The Unemployment Law Project has been around since 1984, and we are the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides low-cost representation and free advice and counsel to people in Washington state who have been denied unemployment or whose award of benefits is being challenged. We are here today with our weekly webinar, which occurs every Monday at noon, and we're glad you've joined us today. The purpose of today's webinar is to share the latest news on unemployment benefits, to provide information about our recently filed lawsuit, and to answer your questions. We'll share commonly asked questions during the presentation, and I'll be monitoring the Q&A chat box to address your questions live today. I'd like to introduce today's speaker from the Unemployment Law Project. We have Executive Director John Turpak and Staff Attorney Ann Paxton. I will now turn it over to Ann so we can go ahead and get started. Thanks, Ann.
Thanks so much, Erin. So thank you very much for showing up for our latest webinar. We're really glad to be able to give you what the latest news is. I'm literally ripping it off the wire service as we speak. Things are happening so fast. So I wanted to start with the major issue that is occurring right now, which is the attempt to extend the $600 PUC payment, which has been in place for several months now. It has technically expired yesterday, but the House and Senate in Congress are still debating how to keep the benefit going at some level. So the latest, and I've just gotten this literally in the last few hours, is that the Democrats would like to keep the $600 benefit going. That is basically the same position that the Employment Security Department in Washington has taken as well. And most of the state workforce agency counterparts of ESD and other states are asking the same. But where they are right now is the Republican leadership in the Senate is proposing cutting the weekly emergency benefit from $600 to $200 until states can bring a more complicated program online. So this is somewhat bad news, but somewhat promising because this is part of another $1 trillion relief bill, which is aimed at stemming some of the economic fallout from the pandemic. Later today, and that could be pretty much any time now, they plan to release the legislation and they start negotiations with the Democratic Party in the House. They want to reduce the $600 to $200 until states can implement a new approach that would pay workers 70% of the income they collected before they lost their jobs. I think one of the stumbling blocks for many Republicans has been $600 across the board. For some reason, people object to that as, in some cases, being more money than people were making in their jobs, which is not a reason to object to it, but that's the way it's seen. But the plan is to possibly phase in a new formula within 2 months under the new GOP plan, but it's unclear how cumbersome that process would be. So this $200 a week would be a bridge until states can get that system in. And there are various proposals to increase what is the average now of about 43% of people's income they can get in unemployment benefits. In Washington state, it's about 50%. At the same time, there's a promise that there would be an additional stimulus check, possibly another round of the $1,200 checks coming as another way to bridge the gap. The legislation at this point has not been negotiated fully, but it does contain an extension of the Small Business Paycheck Protection Act, which would probably add another $100 billion to that loan program for small businesses, which has kept many small businesses able to continue keeping people employed. The Democrats are promoting a much larger bill, and so it will remain to be seen what will occur with that. In Washington state, we are looking at the expiration actually coming up very soon of the job search and waiting week, job search suspension, and the waiting week, which suspension as well. Those have been supported by the Employment Security Department, which has unfortunately has to go, and the governor, but they unfortunately have to go to the legislature to get continuance of those programs, of those waivers. And the legislature has been prone to extend those waivers at the very last minute. So we are unlikely to see for a few days at least what will happen with the job search requirement suspension and the waiting week suspension. So I made a couple of comments about the status of the campaign to extend the $600 PUC payment. That's going to be a significant amount of money for all the nation and Washington as well. Right now, so far under the pandemic, ESD has paid about $8 billion in benefits to about 945,000 Washingtonians. Right now, 500,000 Washingtonians receive an unemployment benefit every week. So each of those are going to see a $600 drop in their weekly income, which will provide a substantial dent in their income and in the economic prosperity of the state. So the Employment Security Department is also promoting extension of the $600 and working on that. Let me go on to this. So I wanted to report on what the leadership at the Employment Security Department is saying about the measures they're taking to address the continuing problems with customer, as they call it, customer access to information about their benefits because of a very, very overburdened and actually crippled phone system, which is to all intents and purposes almost non-functional. Most people cannot get through, very few people are getting through, and many people, when they do get through, are told that they can't be helped. So that is kind of the central problem that ESD says it is working on, but their major priority at the moment is finishing up, taking care of a backlog, which is accumulated, backlog of claims, which is accumulated. They've been focusing on through their, what they've called Operation 100%, on claims that were filed between March 8th and June 18th. And those are people who had not received any payment yet. This is sort of a subcategory of the entire universe of claims that are still not being finalized. But this one subcategory has been reduced significantly, and they say by the end of the month, right now it's down to about 20,000 claims. They say by the end of the month they will have that finished, down to zero. So then they can work on another huge issue, which is the enormous number of claims which are in the adjudication process. So there's still, that's where there is some problem, some difference of opinion, a discrepancy on the claim between what the employee says and what the employer says, for example, and it has to be settled by an adjudicator seeking more information, talking with the claimant, talking with the employer, and so on. But that has bogged down the process greatly of getting benefits in the pockets of people who are owed benefits. So expect that some announcement of that being finished in that one group of claimants being finalized in the next few days. At the same time, the Employment Security Department has been promising that they will have an expanded data dashboard. One of the major complaints, in fact, one of the major topics that's led to at least 2 lawsuits against the Employment Security Department in the last few months, is their withholding of data. We don't know the counts of the number of claims that are in adjudication and stuck there. We don't know the number of claims that were stuck in the fraud identity verification process. Many of those, we have heard that those have been resolved, but we are also continue to get calls from people saying they are not getting their benefits yet. And most significant, the number of people who have appealed a denial and have not seen any any transference of that appeal to the Office of Administrative Hearings, where a hearing date can be set and a judge can actually hear the dispute. So ESD has told us they have a more informal process to deal with those appeals before they go on to the Office of Administrative Hearings. But we have a lot of issues with that because of due process needs not being met. People are being kept in limbo. And we know that there are thousands of those claims. We don't have the exact number of those appeals. We don't have the exact number, but we know there are thousands. When that dashboard is available at the end of the month, we understand that will include data on those appeals, on the adjudication levels, claims that have been paid and unpaid in their system. And we're looking forward to seeing that because it's been a significant topic of conversation for several weeks now. So just to add what the Commissioner Levine said at the last press conference on the $600 extension, she has been in contact, she says, with agency leaders throughout the state on phone calls, and they're deeply concerned about this benefit continuing. They are doing everything they can to support it. You may know that this last week there was a national lobbying effort to let Congress know how important this is. They did receive 16,000 calls, and we've seen, we hope that that's had some impact on their willingness to go forward with the extension. So a major topic for claimants that call us, and for all the claimants that we deal with in hearings, and for pretty much a huge majority of the state, is what will happen when employers ask their employees to return to work, especially if there's a safety issue. In the first place, many of those jobs we're finding are actually disappearing. So people are not being called back because there is no job, or there's a vastly reduced job that's available. So that's vaporized the unemployment rate, and the economy deflating so rapidly has vaporized a lot of jobs, and that probably will worsen as the economic news gets worse with this decline in unemployment benefit payments. And then there's the really central issue of workplace safety, and that is whether people can afford to go to a place to work with other people in an office, even if everyone's masked, even if everyone has social distancing, if there are not every precaution being taken. For example, education of employees about sanitization and about social distancing and so on. So there's a lot of expectation on the part of employers to keep employees informed of that, to make sure that those provisions, that those measures are established in the workplace to protect workers. But it's not happening in many cases. And that becomes a dilemma when people claim benefits, because they may feel they cannot return to work, but there's a strong expectation if you're receiving benefits that you be available for work. What can you do to negotiate that sort of conflict? ESD has made it clear that workers do need to be careful that they tell the Employment Security Department exactly why their workplace is not safe. Of course, there are other reasons why, safety issues, why people might not go back, which is they have a high risk of COVID themselves, or a family member may also be at risk, or they may have childcare issues due to what is going to be a developing situation about the schools reopening. It appears that there's going to be a huge gap there, because many parents, as we all know, do rely on schools to take care of their children during most of the day. These are working parents. So that's going to create a vacuum for an ongoing vacuum for many families. So ESD has told us that they are also upgrading their technology. And this has kind of been a chronic issue, not only with the telephone system, but with their IT system. This IT system was installed in 2017. They've had continuing problems with it, and it has been running at a kind of medium acceptable level with a modest number of claims. But of course, it was not ready for the flood of claims that came in with the COVID pandemic and the lockdown conditions. So, and unfortunately with the IT system, in order to upgrade it, they have to work with the vendor. It's a long process. It can take them several weeks. In fact, that's one of the issues that's arisen with the $600 a week extension. How quickly can states, now that they've been kept kind of in limbo about whether this is going to be extended or not, how quickly can they adjust to whatever system is finally adopted by Congress? So that will be something that will have to remain to be seen. Okay. They have told, ESD says it is trying to get a stronger response to the fraud problem by increasing its data analytics to flag various claims, and by disposing as quickly as possible of the claims that the claim problems that arose because of identity verification. And that was a common comment that we got on calls to the Unemployment Law Project, which was people were getting demands for identity verification. They would submit them, and the computer at ESD refused to accept that they had done so. In fact, people even said they would talk to an agent who said, I can see right here on the screen that you submitted the ID, and I can't understand what the problem is. So there's a definite communication gap between the Employment Security Department and the vendor. But ESD says it has adopted several provisions. One is, in addition to the data analytics, for flagging claims that are problematic. And they are reluctant to give a lot of details because they say it would let the criminals in on how they're trying to defend against fraud. But one thing they've done is a 2-day delay between when claims are made and claims are paid. It was kind of ironic and funny in a way, because 2 days would be an enormous improvement on what we've been seeing, which is many weeks or months. But that is going to be a built-in delay that will help, they believe will help stem the fraud issue. Their advice is that, again, people have to be sure that they file weekly. Sometimes problems arise in claimants because of the complexity of the system. Claimants don't realize that if they don't continue to file weekly, their claim will just automatically be put into hiatus. If nothing will really happen with it in terms of processing. So that's not an obvious feature of the system. So it's important that claimants realize that and keep filing. The other advice that ESD has in order to prevent a common problem, which is freezing of accounts, of bank accounts, because of some contact that the banks received from ESD. ESD says that it is not advising banks to freeze accounts. It gives them the information, and then they have sort of a hands-off attitude. Obviously, the banks are going to react if there's any suspicion of fraud. So that's, again, been an ongoing problem. But they say advise the bank if you're expecting a large payment, such as a back payment of benefits, which should be occurring fairly often if the system is operating as they're promising. Because ESD has made it clear that there is no limit on what they can pay in terms of the $600. The Paycheck Protection Plan actually did run out of money and had to keep being refunded and so on. But the PUA program is good until December 31st. There's no limit on those benefits. And the PUC program, in terms of the extra $600, whatever the claimant was eligible for weeks going back to whenever they started their eligibility, all of that will be covered when the claim is resolved. The date on when the resolution will occur is, of course, up in the air. And they say call the fraud hotline. People have also told us they've had difficulty getting through on that number, but ESD says that is one step people can take. And before we talk about, we wanted to talk about the lawsuits that UOP has been involved in. The Sheridan law firm has filed a writ of mandamus, a petition for a writ of mandamus, which is an order for the agency to take action to address the delays in claim processing. The Northwest Justice Project also has an ongoing complaint filed against the Employment Security Department on due process issues, particularly the factor of claims that are stuck in hiatus, and where the claimant is getting a notice that there's been a denial, but they don't have something that they can appeal. So it's they call it a non-denial denial. It's really stuck the claimant into a due process vacuum. They really can't proceed with an appeal. They have to wait until something happens and they don't know what. So those are the claims that are in adjudication. And I wanted to, John can talk a little bit about the status of the ULP petition for writ of mandamus. I wanted to just mention something that just came in, and that is some good news for the many people who are gig workers in the country. Is specific to Pennsylvania, but it is good news. The Pennsylvania Supreme Court just upheld an Uber driver's eligibility for unemployment benefits, finding that at work was employment rather than an independent business, and that the worker could not be disqualified for benefits as self-employed, which he would be under regular benefits when he started driving for Uber. So that's one of the rare bits of good news in terms of claims of people's eligibility and claims processing proceeding swiftly. John, did you want to say a couple of words about the lawsuit?
Yes. So the case of the Sheridan law firm is not a class action. It's a petition for a writ, and where it's at now is it will be heard by the court probably in the next few weeks. I don't know the specifics of the timing. There have been some briefing and motions and argument back and forth and declarations both from ESD and then from our sides back and forth. Now, it's not a class action, but if the court rules in our favor, it will impact all applicants for unemployment benefits. So it's important that if people want to participate, they can make a witness statement or a declaration. They can contact Unemployment Law Project. I can put my email in the chat here. So if you or someone you know would like to make a statement, what is interesting is we've submitted many of these, and we have over 600 people signed up already to make these witness statements. Is they've been trying to fix some of these to, I guess, show there's no problem. So even though it's not a class action, if you do submit one, there's a chance that your claim might be resolved sooner than others. But we're still advising people to contact their state senator and state representatives. You can go to leg.wa.gov, which is the Washington State Legislature, put in your district. And also, if you are not getting a response from your own senator and representatives, you can contact the leadership in the House and Senate. The Speaker of the House is Laurie Jenkins, and also the chair of the Labor Committee in the House is Mike Sells, and the chair of the Senate Labor Committee is Karen Kaiser. They would be good people to contact, both not only about your claim or a claim of somebody you're working with, but also in general about the problem about how unemployment needs to be funded and the administration of the program needs to be funded. I think it's, a very common problem when the federal government passes something to not have money to implement it. It's called unfunded mandates. And so in March, when the states were told that you will now be including more people in unemployment, you will be giving more money for unemployment, I'm not aware of any increase of funding in the administration of the programs. So So that those are two things that can be done: participation in the petition for the writ of mandamus and contacting legislators. The writ of mandamus um, is something that is rarely done. Most people think of class actions, and people have asked me over and over, why not a class action for damages or others? Nothing in this writ prohibits anyone or any law firm from filing either individual lawsuits for negligence and damages or any class action. So these are not exclusive things. So if there's a law firm out there that wants to file a class action, they are free to do so. And if people want to make individual lawsuits for damages based on their situation, that the fact that they waited for months for unemployment and there have been harm on that. The focus on the writ has been to move as quickly as possible and to help as many people as possible, because class actions often take years due to litigation procedures.
Thank you, John. And we want to turn it over to questions. I just wanted to point you to the eligibility checker, which is available at the ESD website. Again, this covers most of the situations that can arise that are relevant to COVID. PUA benefits under the CARES Act, those are continuing. So there's still eligibility for part-time workers, for gig workers, people who are self-employed. All of those are still in effect until the end of the year. It's PUC that we hope to see some action on, the additional benefit. So Erin, what kinds of questions do we have?
Yeah, so someone received a letter. Actually, the ESD website says that you'll receive a letter about 2 weeks before your PEUC claim runs out, providing details about the extended benefits and prompts you to apply. But they're wanting to know, is there a way to apply manually if they don't receive a letter?
That's for extended benefits?
Yes.
So I don't know, John, maybe you can answer that. I'm not really familiar with the interface, the user interface online. I don't think it's not easy to apply manually. So if you're having trouble getting online, then accomplishing it online, then the really only alternative we know of realistically is the phone. And this is where there's been so many issues. In fact, we had an interesting story came up this week about a woman in Oregon who was actually charged with robocalling because she hadn't actually been selling anything or doing any robocalling, but she had called the equivalent of the Employment Security Department in Oregon so many times that her phone had registered as qualifying as a robocall. So I'm sure many Washingtonian claimants feel the same way because repeated calls have not been succeeding. But that's the only alternative that I'm aware of at this point.
Well, what's happened is since 2017, they haven't allowed paper applications. Some states are still doing paper applications. So other than calling, contacting your state senator and representative may be a way to get a callback from ESD if the website is not working. So go to leg.wa.gov, find your senator representatives and say how you are unable to contact and want to make contact and see if they will set up a meeting or contact them to contact you. I've heard mixed results from many people around the state, but it's definitely worthwhile. There are many excellent senators and representatives with very active staffs who are very dedicated to trying to help as many people as possible. It doesn't always work, but it's definitely worth a try.
Great, thank you, John.
Okay, so another question that we received was, if the waiting week and job search get extended, will we have an announcement later this week?
So the extension, the waiting week and the job search requirement have been They expire August 1st. So that means the legislature needs to take some action before then. Today is the 28th. So we're expecting any day that there will be some action. So I can't say for sure. We're hoping that there will be an extension, but it should be this week.
And it should be on the ESD website. That would be the best and fastest source for that.
Okay, so we have a couple of questions pertaining to substitute education. The Seattle School Board will be voting on August 12th on a reopening plan, possibly 100% online. After this, Seattle Public Schools will have to submit a plan to OSPI. They want to know what will happen to reasonable assurance for starters, and what happens if the quantity of substitute work decreases severely.
So one thing I could say about this year, there is a requirement because of the extraordinary circumstances of the pandemic that the school systems have a plan in place for their reopening, and many of them have not finalized that. So they cannot literally give reasonable assurance until they have that. So that's all I can really say about what is the circumstance with reasonable assurance. John, can you add anything about that?
All I can say is that around the state, I've been hearing some inconsistencies. I've heard of from educators who are getting unemployment in the summer that either reasonable assurance wasn't given or benefits were granted anyway, and others who are not receiving. My advice has been pretty consistent that if you're not getting a benefit and have a denial to request a hearing, if you are getting and it's later disputed by your school district, you should, of course, attend that hearing and get help from Unemployment Law Project. I just want to give a little definition for people on the line who are not familiar with reasonable assurance. There are some general rules that educators cannot get unemployment during school breaks, winter break, spring break, summer break. And the rationale behind the rule is pretty good because most educators might have a full-time salaried position. But unfortunately, substitute teachers and others are kind of brought in under this rule to have them cut off from benefits in the summer, for example, which is very, very unfair since when you're a substitute, your work is inconsistent. There's no way to get your salary spread out over the summer. So that's why it's a big issue. And all the school districts have to do to get benefits denied is in, let's say, May or June, send the substitute a letter saying you have reasonable assurance of coming back in September. So it's led to a lot of injustice. But one thing I do want to add about it is that if, for example, in September, the school districts, even if a person is denied over the summer based on reasonable assurance, if the person is not getting work in September, let's say, they can file for unemployment during regular periods of work. So if the school districts don't open up or use substitutes working remotely, then they would be able to get benefits beginning in September.
Awesome, thank you. And John, could you go ahead and repeat the names you mentioned for people to contact in addition to the legislator? And when you do, I'll go ahead and pop them in the chat.
Okay, so the Speaker of the House is Laurie Jenkins from Tacoma, Laurie Jinkins. She's the Speaker of the House. And the Chair of the House Labor Committee is Mike Sells, Mikesells from Everett. And then from South King County, Karen Kaiser is the chair of the Senate Labor Committee. That's Karen, Karen, Kaiser, Keiser. Mike Sells is Sells from Everett, Sells. Mike Sells. And they can be found at the Washington State Legislature's website.
We lost
Additionally,
you.
we have, oh, sorry, you can go
You're
ahead.
breaking up.
We received a question. Could you expand a little bit more on the upgraded technology for a smooth transition from the PUA to the regular UI?
Yes, I wasn't sure I should bring that up because no, I can't. I don't know the details of that, but they are, what is happening is in many cases, people are on regular benefits, but their eligibility is going to run out and they may need to switch to PUA. How is that going to be done? In the midst of all this other confusion, that could be a very complicated process and invite a lot of delay in receiving benefits. ESD is saying that they are working on technology for that specific issue that is transitioning from regular benefits to PUA. PUA is good until the end of the year, so it should not be going in the reverse direction. But they say they are working on that new technology.
And we have a question. An individual is on regular unemployment, but they need to take care of someone in a high-risk group temporarily, and they're wanting to take on the FFCRA. Can they claim unemployment and FFCRA at the same time?
FFCRA, John, do you know what that is?
I'm not sure. I mean, I might know what it is, but not under that acronym.
If it's paid family and medical leave, you can't receive that at the same time as unemployment benefits. You cannot receive workers' comp at the same time as unemployment benefits.
That person can contact us. That person can email us individually for like more clarification.
Yeah.
I'll go ahead and message your email, John. Going back to the substitute teacher conversation, would it be a good idea for the substitute teacher to claim UI in September if they think it's likely there won't be a good enough opportunity for work?
Yes, substitute that if during regular school year, September up until winter break, and then from after winter break until spring, a person who's unemployed through no fault of their own should be able to get unemployment benefits. You would be asked each week when filing your weekly claim, are you able to work and are you available for work? And if they have the job search requirement, then if you're searching for work, but you should be able to get it. And they ask you every week if you worked. So I've talked to many substitutes over the years who will get a partial unemployment check. So some week there's no money from work, so their unemployment benefit is 100%. Others, they may get 1 day of work, so they would be asked how many hours they worked and what their pay was, and then there would be a calculation of a partial amount.
Can you review the extensions currently in place for regular UI?
Sure. So right now, they're in place right now is the suspension of the job search requirement. So that means that people do not have to keep a log of their job search contacts. They do not technically need to look for work, although it's always advisable to make some contacts because you do need to show that you're available to work, even if there is a job search requirement suspension. That is right now expiring August 1st, and we should find out in the next few days whether it will be extended again. The other provision that is also in place is the waiting week, the waiver of the waiting week. Right now, under regular benefit program, there is an automatic 1 week waiting period after you apply for benefits that you are asked to wait, and that has been suspended under the CARES Act. The federal government is actually covering that former waiting week. That's good right now in Washington State until August 1 as well, but it may also get extended by the legislature. The only other thing that the only other thing that can be extended is the PUC, that is the $600. That could be, that could still be re-extended if Congress acts very quickly.
So we have another question. It sounds like this individual has been locked out of their SAW account, so they've been unable to make weekly claims, and they're hoping to have a hearing date coming up, but they want to know how they should handle not being able to make those weekly claims in the meantime.
Well, if you're doing a job search, keep track of those job searches, but that's a good thing since they're not really answering the 800 number now in order of getting your claim opened up, to contact your state senator and representatives for help with that. Because even if you have a hearing and win and the judge says benefits are allowed, that helps you, of course, because the judge is saying you are eligible for a certain time period. But if mechanically you can't claim for those weeks or be in the system, that order from the judge won't help you too much. So it's important to attack this from more than one angle and, you know, pursue the hearing, go through the hearing, and we hope you win. But as well, work with your state senator and representatives of getting your SAW account open back up, because if you don't claim for certain weeks, they do allow, well, if you don't claim for certain weeks, you won't get the money even if a judge says you're eligible. But there is a rule about backdating, so there's good cause for backdating. And so the backdating is allowed, and a circumstance like this would fit good cause, where you actually tried to claim or wanted to claim but could not.
And I wanted to add something to my answer before about the extension of benefits. That was my misunderstanding of the question. So there are two extensions of the normal benefit period under regular benefits, which is 26 weeks. That PUA, by the way, is good until the end of the year. But the CARES Act has added a pandemic unemployment PUC, pandemic employment compensation and extension. So they have they will add a 13-week extension up to 13 weeks as long as you're eligible for benefits to the 26 weeks max, which currently applies in Washington State. Once that expires, there is a program called extended benefits, which is also covered in part by the federal government, but that's a regular program. That is 20 extra weeks, up to 59 total weeks. However, when extended benefits kick in, it's important to recognize that that drastically changes the job search, the job availability requirement, because if you have been unable to find work in your field, which would be generally what would have happened after, say, 39 weeks without work, then you are expected to take, in Washington State, you're expected to take any job that you are physically capable of doing. So that is a very different environment in which to be looking for work. So it's not, the extension is not an extension that you might, of what you've been would have been receiving up until then. The job search requirement and the availability requirement is very different.
Can you clarify backdating?
What backdating means? So John, can you comment on backdating? I'm not as familiar with that.
Well, backdating is, well, okay, so usually a person, let's say they lose a job, they open up an unemployment claim, and even before the claim is decided, they make a weekly claim answering a series of questions. So each week, there's eligibility looked at for each week. So let's say the claim goes through, but there are circumstances where a person either can't claim, or they tried to, or they had circumstances, for example, maybe they were denied originally and then they had a hearing and benefits are granted going back, where they want to go back and backdate their claim to the, the weeks in which they were unemployed that they should be eligible for. So there's a rule saying backdating or a late claim can be allowed for good cause due to circumstances. And so that way, like for example, people I talk to who open up their claim in March, they try to claim, but then their account just shut down or it just wouldn't let them claim. They call the 800 number, 30 times, no response. Finally, somebody gets back to them in May or June and allows the benefits. Well, their accounts open up, they're getting benefits, let's say from June on, but they need those benefits from March, April, May, so they can apply for a late claim or to backdate their claim for those weeks in which they were unemployed. And they should only try to backdate for a week where there's no income. Like if your employer was paying you when you couldn't work, you probably shouldn't claim for those weeks unless it was a very small amount. But in general, if you were unemployed with no income from your employer, you should be eligible for those weeks. So good cause for backdating is often allowed by ESD. However, many cases, an adjudicator might say, well, that's not enough. That's not a good reason. In that case, read your notice carefully, request the hearing, and call Unemployment Law Project for help when you get a hearing date.
Okay, so we have a question from one individual who was laid off and they began filing in early May. They believe that they should be fully eligible, but they haven't really had any changes in their claim, and they're curious whether or not they should be applying for PUA, PEUC, or UI. They're mostly confused just because there hasn't really been any changes and they can't seem to figure out the status of their claim.
So this is unfortunately a very common problem because so many claims are stuck in adjudication. So there is a lot of lack of movement on those claims. I think the person might mean PUC, which is the $600. The PEUC is the extension of benefits for the extra 13 weeks. And that is applied in a lot of cases. I think this person's referring to an inactive requirement that it be an inactive case. If your benefits already ran out sometime after July of last year, it's possible you qualified or could qualify for PEUC. That is additional weeks that you wouldn't have been able to get back when your claim expired. So those are possibilities in this case. And again, the issue about the claims being frozen, the claims status of the claim being unavailable, that's again something, contact your legislators. You can also try getting in touch with the press and the Unemployment Law Project as well about your case. We may be able to add you to, we would be interested in talking with you potentially about joining as a declarant in the lawsuit, on the petition for writ of mandamus.
So
yeah,
one thing I would like to add about these, at a webinar like this, we can answer some general questions, but this probably sounds like something that should get individual advice because there's a lot of things going on. In general, the rule is you may be eligible for pandemic unemployment if you're denied regular unemployment. And so many of these cases are stuck in between and we're not sure where it's going to go. And I've heard conflicting information over the years from over the months. It feels like years, but it's been months from the ESD in terms of what a person should do. In general, I would say that if you're applying for more than one program, there's no harm there because unemployment is not going to give you pandemic unemployment if you qualify for regular. As long as, and so it's important when you do apply, if you apply for multiple programs, to answer the questions to the best of your ability. So it's correct information because there's no harm to this. Like people have asked me, well, should I apply for the extension? I don't know if I will need it or not. Well, if you apply for it and your claim is in the system and you end up not needing it, let's say you go back to work at full salary, then you don't need it. You don't need to use it, but it might be better to apply for it and have it ready rather than waiting until your benefits run out and then attempt to apply for it.
One person has a question between the distinction of PUC and PEUC because they haven't been able to see PUC on the ESD system, which is what I believe you referenced, Anne, when you were talking about the 600.
Because they haven't been able to see what? I didn't hear. You broke up.
Yeah, so the term PUC, this individual hasn't seen it on the ESD website. So they're confused because they thought that the PUC was the same thing as the PEUC, as they've never seen PUC on the ESD website.
Okay, so yeah, pandemic unemployment compensation would not necessarily show up on the website because it's an automatic add-on to whether you're receiving regular benefits or benefits under the PUA paid for by the federal government. So it's federally covered add-on. But many people do confuse it with the very similar sounding PEUC, which is the emergency extension under the CARES Act, which adds 13 weeks to your claim. So I have seen people reference seeing the ESD mention online, PEUC. Wouldn't necessarily hear about PUC, but many people confuse the two in any case. But if you need to apply for PEUC, sometimes that will appear on the screen as an option if you are already receiving regular benefits or if your benefits are about to run out.
So we are running out of time. It looks like there's only about 5 more minutes left. So I'm going to do one more question. And if anyone else has questions after that we didn't get to, feel free to email us those follow-up questions and I'll put some emails in the chat box. This last question is, who do I contact at ESD about being locked out of my account due to an ID verification issue? I have submitted the documents they need and they have confirmation, but ESD keeps saying they don't have it and representatives have told them that they can't help them.
Well, I would urge you to contact me directly, making a statement for the declaration for the court case would be helpful, but also maybe we can see about other avenues of contact. If you contacted your state senator and representatives already, you could also try federal representatives like Pramila Jayapal and Kim Schreier. Their offices are helping people. And also the Speaker of the House, Laurie Jenkins, and Mike Sells, Chair of the Labor Committee and in the House, and Karen Kaiser, Chair of the Labor Committee in the Senate.
So question then, one individual has tried to backdate, but they haven't been able to do so effectively. Can you explain that process real quick?
Well, what they should be doing is sending you a denial letter saying, we find that you did not have good cause to backdate, and here are your appeal rights. So that's what they should be doing. Again, if they are not following that procedure and they are not granting or allowing a backdating or a late file claim, then you should contact your representatives, your senator, your representatives, and also feel free to contact the Unemployment Law Project for help as well.
You see, I see that there's a question about a recording of this session or being available online. Do you know when that it is being recorded, right, Erin?
Yes, it is being recorded, and we will get that up as soon as possible.
Great.
Yeah, as for the rest of the questions, please direct them to our email. I will put that in the chat box one last time. Otherwise, thank you so much, everyone. All right.
Bye, thank you.
Thank you.